All right, the court will call the case of LVNV Funding LLC versus Lucretia Carr. Case
Good. Oh, sorry.
5C87.
Hello.
Good afternoon, Your Honor. Alexander Popov appearing on behalf of plaintiff.
Thank you. Ms. Carr, please state your name for the record.
Lucretia Michonne Carr.
All right, thank you. All right, we're on here on a motion to set aside the default judgment in this particular case. Ms. Carr, you filed this motion. There are two things that you have to be able to prove to the court. One is that there was good cause for the fact that you didn't show up to court, and two, that you have a meritorious defense, a valid defense to the claim. So both of those things have to be proven.
Yes. My first initial reason, I didn't know exactly how a summons works. And I had a few things going on at that time. I had an eviction I was in court for at the time, and I just didn't know what a summons was. I had never had one before. I thought that I was waiting on a court date to come to me. I didn't know that I had to go to the court and file an answer to the situation, and till I called and I spoke with someone, and then I figured out what my next steps were to discuss the situation. And then naturally, when I look at the information of the summons, the even paperwork that I received, I did not. I was looking for a purchase agreement, legal authority. I didn't see my name, my account number, any of the things that are the bill of sales. And then I had wanted to do more research because I had a few different people contacted me about this same account. I even have an email from a different company that claims that they have this same account. So I don't even know what's actually happening at this time with this account.
Thank you, Judge. Going by her motion, she stated that she had good cause because she didn't understand what the summons meant. The summons clearly directs the defendant to respond within 21 days. Therefore, we would argue that she doesn't have any good cause. If we go to the meritorious defense argument, in her motion, she said there was no meeting of the minds because multiple creditors contacted her. She hasn't provided any evidence of that, and if so, it's immaterial because there was mutual assent between the two parties, and the statements reflect that with payments and purchases. Therefore, we would argue that there's no meritorious defense either, but she hasn't provided good cause or a meritorious defense.
What does assent mean, so that she can understand that big word you just used? She's not an attorney.
Sorry, that we both came to an agreement.
And you're saying that was evidence because she spent using the account?
Yeah, so we gave her credit to use the account, and she utilized the account by making payments and purchases.
Oh, and case law says?
The case law I can give you right now.
But the case law says if you do that, then that is considered mutual assent, correct?
Correct.
Did I had the account with you?
You have an account with his client, ma'am?
And his client is?
LVNV funding.
And see, I don't have an account with LVN funding. You're saying that I had an account with it. LVN funding, I never opened an account with them. I never signed any paperwork with LVN funding.
Yeah, so my client purchased the debt from the original creditor, which was Credit One Bank.
That's not what they said. They did not purchase it from the original creditor. I have some paperwork here that says they purchased it from somebody else.
So there is a chain of title. But we own LVNV. My client owns the debt.
But you said that I had an account with LBN, and no, I didn't. And they didn't buy it directly from that company.
It doesn't
We
matter whether whether they bought it from that company or not. They attached the bill of sale to this, and an assignment of the account is attached to the actual summons that you were served with.
And there's no purchase agreement.
Ma'am, you don't get to fight that once there's an assignment. That's not for you to fight. That's between him and whoever. If they have an issue as to whether or not it's a proper purchase, you don't get to make that. That's not your argument. Make.
It's not my argument to make that if there's a purchase agreement with my signature and stuff on there. I mean, not the purchase agreement. I'm sorry. I'm looking for,
Well, first of all, before we even get to that issue, I was just trying to address it because you brought it up. The first issue, ma'am, is that you can't come to court and say that I didn't know I was supposed to answer a summons. The summons tells you right at the bottom that you have 21 days after receiving the summons and a copy of the complaint to file a written answer with the court and serve a copy of the other on the other party or take lawful action within 28 days if you were served by mail or you were served out of the state of Michigan. It tells you right at the bottom what you're supposed to do.
unfortunately, I didn't understand what the paperwork was, so I didn't even process what that was saying to me. I didn't even know that's what it was saying.
Well,
I had never had a summons to court before.
the more unfortunate
And
piece.
then I Googled summons and it said that I would be sent something in the mail
Ms. Carr,
according to a court date.
Ms. Carr, I know you hear me talking to you.
I apologize. I'm not trying to irritate you. I was just telling you what from my understanding.
Again,
I'm not trying to.
stop speaking over me.
When I'm speaking, you wasn't speaking. I'm sorry. I wasn't trying to speak over you. I'm just trying to understand what was going on. And I just didn't understand
You
it.
started talking. That's what's going on. I was explaining. I was actually reading when you started talking, ma'am. So please don't do that. Okay?
Okay.
So as I was reading to you, this is what is required by this piece of paper. Whether you have an understanding of that or not, doesn't change the fact that you were served with the document that says that. The law says that you are required to read it and to understand it or to get legal assistance. You don't get to come to court and say, I didn't understand it. That's not the way this works. Now, what is it that you want to say?
I don't know. I mean, I know what it says, but I just didn't understand it. So, I mean, if I didn't understand it, then I called to get some advice to understand what was being said and what's handed and what was given. I just didn't understand what the paperwork said. I mean, I don't know. I know what the law says. I know what the paper says. But when I read it, it didn't process to me what I had to do next. So I called and I spoke to a clerk and they directed me to that area. And I said, oh, this is what it says. And then I didn't know. I just didn't understand it. I know the law wants me to. I know I may be irritating you, but I just didn't understand what I was reading. And I had wanted to apologize and see if I can have the opportunity to look over the evidence and see what I was being, sued for and who was suing me. That's all. I just didn't know. I apologize. I have the opportunity.
I'm not. All right. Are you done yet, ma'am?
Yes, I am.
All right. I'm not asking you to apologize for not understanding. That's not what I'm upset about. I'm upset because when I was talking, you kept cutting me off. That is irritating.
Yes, ma'am.
As to the second part, because there are two prongs. Even if I were to give you the benefit of the doubt, then you have to get to the second prong of this, is whether you have meritorious defense. And the things you're talking about are not a meritorious defense to this. There is a proper bill of sale that they have that allows them to actually sue you. So the second question is, what are you trying to tell me about your defense? Because there's no purchase agreement. That's not what this type of case is. So what are you trying to tell me about that?
I was thinking, I didn't mean purchase agreement. I was looking for more information for the company to have because I'm not a lawyer, I do not know all of the information. I had a short time to research a few things. I would need more time to research a few more things of what's all needed to be provided to say that they own the debt and that I am responsible for the debt. That's all. I just needed more time to look over it. My opinion, I didn't see any of my account numbers in any of the information that was given over. I didn't see any dates on any of the paperwork when the signatures was put on there. I didn't see any of that.
All right. So when a action is filed in court, ma'am, first things first, no one puts full account numbers on it. They're supposed to be blocked out. That's considered personal identifying information. So you would not receive it with that on there. Secondly, the bill of sale is attached showing that they now own the debt and they are able to sue you for this particular action. Before I make a ruling on your motion, do you want a chance? And this is over a credit card debt with Credit One Bank. So it's a very cool thing. You can talk to them and see if you want to resolve this before I make my ruling. Maybe they'll work out something with you, or you can choose to not talk to them and I can make my ruling. Do you want to try to talk to them and see if there's something you can work out?
Sure. I don't mind talking to them.
Okay. We'll see if there's something the two of you can work out. I'll put you in a breakout room first and then I'll call the case, okay?
Okay.
Thank you.
Yep. Okay. Go! Will you hand me my screen box? Now go.
All right, the court will recall the case of LVNV Funding LLC versus Lucretia Carr, case number 25C 1087. Where are we with this matter, Mr. Popoff?
Judge, we were unable to reach a resolution.
All right. So, having said that, then I will have to make a ruling on the order regarding the motion to set aside the default. As the court has indicated earlier, there are two standards that must be met. One is that there's a good cause, meaning a good reason to find that the defendant did not show to court or did not answer the complaint. As I indicated earlier, the fact that the defendant didn't understand the document is not actually a good reason to not set this aside. In addition to that, I haven't heard anything that would satisfy a meritorious defense. The motion to set aside is denied. I will sign an order to that effect. We're all set here on that particular case. Have a good day.
You too, Judge. Thank you.
All right, the court will call the matter of Portfolio Recovery Associates LLC and Shatina Grady. 24C 2622.
Thank you. Good afternoon, Your Honor. Daniel Best, P58501 on behalf of Professional Recovery.
Thank you. Please state your name, ma'am.
Shatina Grady L.
Thank you. All right, the last time we were here on this particular matter was back on May 22nd, 2025, when I granted Ms. Grady L's request to stay this matter and compel arbitration in this case. And it was set for a review today to determine whether she had filed or we were moving forward on the MSD.
So I come today to have my motion for dismissal requested. And
Ma'am, what happened with the arbitration?
So there was no arbitration because that attorney that took the information mysteriously emailed it to the wrong email. I called them on May 23rd, on June 9th, because I had checked my email. If you will recall, at the end of that last court date on the 22nd, the attorney that spoke or sat was supposed to send me information regarding arbitration. I checked the email every single day. There was nothing. On June the 9th, I called to find out why I had not received anything, and I had to leave a voicemail. I did that. I called on July the 1st to find out why I had not received anything and what is going on, because I'm still checking the email. Nobody's called me back. Nobody has reached out to me by mail, nothing. On July 2nd at 8:37 in the morning, they had a representative call me. When I spoke with Kelly at 3:02, finally getting in touch with someone, she said, even though this attorney at the last meeting repeated the email back to us, managed to misspell the email when they sent out the arbitration stuff. So as of today, when I checked, I still have no arbitration stuff, because on the 2nd, when I spoke with Kelly, I gave her the corrected email. I don't understand why this firm is unable to get me the information that I need, either not at all or in a timely manner. I don't understand why, when they can repeat back to me what I have given them per the email, that mysteriously one letter gets changed. So arbitration has not gone through on the failure of their behalf.
Mr. Best, response?
Thank you, Your Honor. I was that attorney. I repeated back the email address that was provided by a defendant. I reiterated the E because it was not her last name. I mean, not her first name. It was Shantine, not Shantina. And I got confirmation. I completed the order, and it was an order of stay. There was nothing in that order that would preclude defendant from seeking the arbitration as was ordered by the court. So the email that was sent was not returned undeliverable. We did not have any notice that there was an issue until yesterday when my staff returned the call. Admittedly, we did receive ISHO on June 10th, a call that was misrouted by my receptionist and was not returned. But the bottom line is, at that hearing, the court gave defendant until today to initiate the arbitration. Nothing in that order was needed by her to initiate the arbitration, and the arbitration was not initiated.
So in response to that, at the last court date, I spelled out SHATINA G 317, and I said G for Grady, right? And so you repeated that back to me. First, you asked if it was the E, because in the new name, it is SHATEINA. And I said, no, it's not. You asked me, was it going to be spelt that way? Because it's different from what, and I said to you, no, not to that name. We're not spelling it that way. We're not using the E. I specifically said we're not using the E in Shatina, SHATEINA. And then I also said G for Grady, 317 at Gmail. But the email that you sent it to, if I'm telling you there's no E from what you see on my sign-in, SHATEINA, because that's what's on my sign-in, I told you to omit that E. That doesn't go there. We're going to, it's spelled the way that it's in the court papers that you filed suit of, if it's in front of you. You filed suit for SHATINA, okay? And then Grady. And then as to what you sent me, and you saying that the court said that I had to do, if I want to seek arbitration, she asked me, did I know how to do that? I said, no, but I could figure it out. You said Well, I can send an email. Whatever your specific words, which is why I'm getting transcripts printed. I don't know what your specific words, but you cut in and said that you would send me the email. That's when we got to the email aspect of it. That's how we got to the email aspect of it, because I had said, she asked me, did I know how to do it? I said, well, no, but I can figure. And you said, well, I can send. You said, I'll send an email or whatever your wording was. You didn't say anything about sending whatever you just said that you were going to send. So again, you're playing games, and you're being dishonorable. You're being deceitful. You have not request.
Miss Gradio,
Yes,
please stop going down that line.
I'm just
Because-
telling.
Miss Gradio,
I'm
the
just telling.
reality is that you came in here and you asked for an arbitration.
Yes.
And I stayed this matter and gave you an opportunity to file that. So,
But he also said, when you asked me, Judge, you asked me, and if you needed to run the transcripts back, we could do that. You said, do you know how to do that? I said, no, but I'm sure I could figure out. And he said, as a cut-in, that he has a packet that they normally send out. Nor not I have received that packet, but I didn't receive an email for it. I knew that I would probably not get any response until close to the court date. Like, I knew that. That's why I even called on June the 9th. That's why I even asked if there was a note I could send you at the court. And I was told no. I knew that they would try and do this, that their people called me just now, yesterday. And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere that they have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
Ms.
And if
Grady,
the court
Ms. Grady,
understand.
I've adjourned this case, I don't know how many times, give you an opportunity so that you can be prepared. So
And
please don't interrupt me. Please do not interrupt me. Please. Today we're back here, and I'm not happy with either side. Because one, Ms. Grady, if he didn't send you the information, you could have done what you said you could do, which was figure out how to proceed with the arbitration. And Mr. Best, on this particular case, at each and every turn, there's something that comes up that doesn't go right, which complicates this matter even further. So if she's calling you guys, and now with that particular call, it gets rerouted, and like she said, she doesn't get the call back until yesterday. And as far as an appeal, appeals don't scare me, Miss Grady. I don't mind that people appeal. That's for a higher court to decide if I've done something wrong. But I try to do my best to do the right thing by everybody that comes before me. And I've given you many opportunities. So, Mr. Best, I don't recall the specifics of that part as to whether there's a package.
I have no package, Your Honor. I have no packet. I have, and what I agreed was I would provide the order granting, or that's what I believe I was agreeing to provide, was the order granting defendant's motion. It's normally the party who brought the motion's obligation to do the order. My remembrance was she did not know how to do the order, and I agreed to do the order because I have a standard one that we do on these cases. I would never agree to provide legal advice to a defendant on how to file an arbitration. I do recognize that my office did drop the ball with respect to the order and getting it to defendant, but I insist that The information I took down is what defendant provided. Granted, we did not properly follow up and we did not properly respond to her voicemails, but it's strictly the order.
And in reality, where we are right now is this court doesn't have an order in it referring it for arbitration or a stay or any of that, because the order was never submitted to the court either.
So what I would propose is that we provide, I believe it was 45 days originally. I don't want to keep kicking this out, but we go out 45 days, which would roughly be August 18th. And that she file it by then. I am not providing her any instructions on how to do so. I will submit the order under 7-day.
So we are all clear, Ms. Gradiel. He's submitting the order that says that I granted a stay and that you are to file your arbitration within that time period. It will not say anything else or provide any packet for arbitration. It will be your responsibility to figure out how to file your arbitration. Okay?
I hear you, Judge, but I would ask for a dismissal.
That's not how this process works, Ms. Gradiel, and you can file whatever motions you want to file around that.
I feel biased upon.
Okay, then you can feel however you want to feel about that, and you can file whatever you need to file.
Your Honor, if I can, I'm actually out of town the 18th and 19th of August. I would like to be the attorney who handles this. Could we schedule that either? I got a dentist appointment on that Thursday. Does the court hold these strictly on Thursdays?
Strictly on Thursdays, and the 18th wasn't an available date anyway.
Right. The 21st would be the available date. I do have a 1 p.m. dentist appointment, but if we could go, I have a very good dentist. If we can do it at 3 o'clock again, that would work.
So, counsel, you're going to submit the order granting the stay and providing her with 45 days to file her arbitration. And
Correct.
that will be submitted under the 7-day rule. Ma'am, the 7-day rule provides that once the order is submitted, you have 7 days to provide any objections you may have to that order. Court date will be scheduled for August 28th, 2025. This is the last date for that arbitration to be filed. If it is not filed, once again, I will tell you, your MSD will be heard that day. His MSD will be heard that day if it is not filed.
And just for clarification of the order, is it 45 days from today's date, 45 days from the entry of the order, or by August 28th?
Let's just make it by August 28th. When we come back here, that arbitration needs to be filed.
Very good.
Thank you.
Thank you. Have a good day, everyone, and a happy 4th of July.
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. He's an interpreter.
I need an interpreter when I cannot express myself somehow.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No paper left. Trust me, after today, I'm sitting up here, I'm the one that needs a drink.